Hello, and welcome to Hospice Insights, the law and beyond, where we connect you to what matters in the ever-changing world of hospice and palliative care.
Surprise! What hospices need to know about the No Surprises Act. I'm so excited, Andrew and Noreen, to have you join me on this topic that I think most of our listeners are like, what are you talking about?
Right.
No Surprises Act, because I think we are bombarded by so many changes. And I guess before I turn it over to you, Noreen, to talk about what is this No Surprises Act, what does it require, just the caveat, like, we're not getting into every single detail of the No Surprises Act. My guess is we'll do additional podcasts as things develop in this area, because I think it is a very sort of broad requirement, but there's not a lot of regulation. I mean, things are developing as we're actually speaking. I know that there was some new guidance that came out, even like you said, today or yesterday.
A couple of days ago, yeah.
We also do have in the liner notes of the podcast a handout that people can get and download, which we'll talk about in the podcast. So this is not the end all be all in this No Surprises Act. This is like a tickler of, hey, you guys should be thinking about this. So what, Noreen, and you, thanks for joining us today. What is this No Surprises Act? And there's also, references to good faith estimates, which are, and we all need more acronyms, GFEs. So tell me, what is this world that we're talking about?
Sure. So first of all, thank you for having me to talk about a law that really probably your audience is thinking, gosh, this doesn't even apply to me. And for the most part, they'd be right. The No Surprises Act is a newish law that went into effect kind of at the beginning of 2022 and largely applies to health plans and insured patients. Its goal is to protect patients from out-of-network balance billing, kind of the big bills that arrive by surprise in the mail after you receive emergency conditions, or you're going to a provider and they're out of network. So that's what the rule at its core is about, and it mostly applies to hospitals and general providers. However, the GFE requirement, good faith estimate, is one element of the rule that applies to all providers. The departments who are in charge of regulating it and putting out these laws are viewing their authority very expansively, and they have not excluded any provider. And it requires a disclosure in a form to patients who are self-pay or private pay patients. And that's the kind of tiny part of the No Surprises Act that your audience is probably interested in, because it is a new disclosure and it is a new form, and there are penalties to not complying with it. So really what it is that when a patient either is self-pay, they don't have any insurance, they're paying, out of their pocket, or they may have insurance, but they choose not to use it. They want to pay, cash for whatever reason. The No Surprises Act requires that providers disclose this to patients, that they have a right to receive a GFE. And also there's a form that providers fill out and actually tell the patient what is their good faith estimate of the costs of the service that they're going to receive from that provider. So here it would apply whenever a patient is considering accessing hospice services or palliative care services and doesn't have insurance, or maybe has exhausted benefits or somehow paying cash. It's that point when your providers want to give them this notice and how much it's going to cost after all discounts.
And we're going to get into what needs to be on this good faith estimate in a second, but let's drill down on, Andrew, what this means for hospices, because 95% of our revenue comes from Medicare. So in those situations, the this good faith estimate is not going to be applying, right? Because Medicare is covering it. Do I have that right, Andrew?
Yep, you do. Yeah.
So then let's just say the remaining 5% of our revenue could be Medicaid. So for our Medicaid only patients, how does that link in here? Does that matter?
Medicaid, well, if Medicaid is covering hospice care for a patient, then this good faith estimate would not apply.
So we shaved off our Medicare fee for service people. We've shaved off Medicaid. That leaves us with self-pay, which
Yep.
is
Yep.
very small. And I would say you and I typically deal with that in charity care situations, right? And
Exactly.
oftentimes you're charging people on a sliding fee scale anyway, because they don't have any funds. And so, and maybe hospice is, again, different in many respects from the rest of healthcare, but we have pretty generous charity care policies. Many hospices do. So, but why don't you talk about how this intersects with self-pay? Because that's the first time I think this really comes up for that small segment. So, So work that through for me.
Yeah. Just like you said, I mean, typically we're going to be talking about like a true, self-pay or like charity care patient. There could be a patient for whom Medicaid coverage is pending. So at the time the services are delivered, the patient would technically be self-pay. But I think importantly, and we were kind of talking about this, there are circumstances in which a patient technically could have insurance, Medicare or Medicaid insurance even, but the particular services at issue might require a good faith estimate if the patient requests it. So I guess there's kind of two categories within that bigger category. So first, if a patient has insurance, but the plan never covers the service at issue, then for purposes of that service, a patient would be considered self-pay. So typically here we're talking about like residential services, which for a hospice patient aren't covered, including by Medicare. So if a hospice is providing residential services because a payer really isn't going to be paying for that,
because it's not part of the benefit.
Exactly.
Right?
Exactly.
So if we're funneling this down, that typically only happens largely when people have their own inpatient unit and people hold over and stay. So you're saying if we provide residential services to a hospice patient, we would have to give this good faith estimate, which I think, and we're going to talk more about this, most people already do, because our recommendation is you should have some written agreement that says, here are the costs for this, there's a per day rate, blah, blah, blah. Right.
Yep. Exactly. Yeah. Although I think Noreen will get into this a bit later, but the good faith estimate, I think the expectation is really that be a separate notice document. So yeah, just to your point, we already kind of recommend that hospices have these types of residential agreements where kind of the patient responsibility is set forth very clearly. However, it doesn't sound like that would satisfy the No Surprises Act requirement, given that, again, the regulators want that to be through a separate notice. Sticking within this category of patients who do have insurance, so we already talked about, well, they have insurance, but the payer doesn't cover a service at issue. So if we talk about like Medicare, for example, Medicare statutorily covers a variety of services, but in order for Medicare to cover the service has to be, in the case of hospice, medically necessary for the palliation and management of the terminal illness. So there could be services that are normally covered, but in a given instance are not covered because they're not medically necessary. And if the hospice is going ahead and providing that service, because the patient wants it and the hospice agrees to, because a payer isn't paying for that, again, that would be a situation in which a good faith estimate provision would apply. So, kind of connecting this here to the ABN, the situation I just described is basically a situation where you would have to provide an ABN. So essentially, whenever you have to provide an ABN, again, because you're providing a service that is statutorily covered but not covered in a given instance, you would also have to provide the separate good faith estimate.
So, but hospices don't have to provide that service.
No, nope.
So a lot of people, because you only have to give the ABN if you're going to provide the service, right?
Yes,
Same with the good faith estimate. And so if someone wants something that you think isn't medically necessary for palliation management of the terminal illness, they've waived coverage, right, with their hospice election on that. Now, if they want that service, they're going to be personally responsible for it. And you want to provide it. Again, these are a lot of ifs. I don't know how many hospices are really going ahead and providing those things. If you did do that, you'd have to give this good faith estimate. So that's another example. So one is residential services, if you're going to provide that, which is probably going to be more common than the second one, which is there's something you're going to provide that is not medically necessary, but you're going to provide it anyway. You're given ABN. The ABN is not enough. You have to give what Noreen's going to talk about, this good faith estimate. And then maybe before we turn it back over to Noreen to talk about the content elements of this good faith estimate, what about charity care patients and Medicaid pending people? Those are sort of the self-pay categories we have. Because as we know, you may think someone's eligible for Medicaid, but that can take a while to get confirmation that they actually are. So tell me about those patients.
Yeah, those patients, they're kind of more just in the, more straightforward category of self-pay because they actually don't have insurance. So either they are true charity care patients, and they're paying out of pocket, so to speak. Although, again, as you said earlier, hospices typically, have a sliding fee scale. So if you're lower on the federal poverty line, you're going to pay less than, if you're higher on the federal poverty line. But again, because those are self-pay patients, the good faith estimate requirements do apply. And same with Medicaid pending. So at the time that you're delivering these services, they don't have Medicaid. Medicaid is still pending. So even though they may get Medicaid down the line at the kind of relevant time for these purposes, they don't have insurance. So again, the good faith estimate would apply.
This is so confusing, right? We spent an hour preparing for this podcast to try to pick through when does this actually, because I think for hospitals and physician groups, it's so much easier to figure out when this is actually going to be an issue than for hospice. But I think that's really helpful. So to just recap for our listeners, when you have self-pay people, so that's going to be Medicaid pending, charity care patients, then if you're going to provide residential services to anyone, because there's no, benefit that covers residential services, because typically, it's only covered if you're in a nursing home or whatever. That's probably something you need to think about. And then the last category is if you're going to provide something that's not medically necessary, you're giving an ABN, and then you would also need to give this. So those are the four instances that we could readily think of that this confusing law may apply to hospices. So
yes.
But when we talk about this confusing law, Noreen, this good faith estimate, there's a form. You talked about this form that CMS has, and we're going to link to that in the liner notes. And then I know we have some ideas about putting stuff on your website, but the law is very confusing. But what is it that you actually have to do?
Sure. And that's a really good point about the confusion surrounding this law, in that it's a law that largely applies to health plans, and many providers are not aware that there is a section that requires process. Many providers have letters, handbooks, different documents in place that explain how they charge for their services. And those existing documents may be very compatible with what the good faith estimate requires. And however, the departments, and when I say the departments, I mean the federal departments of labor, health and human services, and Treasury through the IRS. These are the three agencies that have joint authority. And they have been very clear that they want a separate disclosure that contains certain information. It can be on the provider's branding and their logo. It can be interwoven and have the voice of their of their culture and how they speak with their patients, but it has to contain certain criteria. And essentially that is, what is it? What is self-pay? When are you considered self-pay? What are your rights? You have the right to expect this before you access the service, enough to give you an opportunity to reject the service and go somewhere else that may cost separately. And then you have to post this notice on your website and then really anywhere that the provider may talk with a patient. So that could be in an office setting, it could be at a home, it could be at a hospital. It's very individual to the actual provider. There also is a form that it's a template form, and you fill out your own provider information and then the services, what they're going to cost, and hand it to the patient. The departments have provided this paper form. There are vendors and kind of electronic versions of this coming online with different vendors. So you might see it through, you might be getting some notices or see, marketing materials about these kinds of services. But that's really what you have to provide. So while you may have this information already in place and you're thinking this only is going to apply in a very, very few situations, there are penalties to noncompliance, and the departments are enforcing penalties of noncompliance and contacting providers and asking questions. So it is a good risk management opportunity to take a look at your documents, what you have, and make sure it fits the criteria. There is a $400 buffer zone, and that's kind of what it costs. Your estimate, what you give the patient, that cost needs to be within $400 of what the actual cost ends up being. And that's depending on, the service, that's either a big spread or a very small one. And if you go over that, or if you don't provide the GFE at all, the disclosure and the costs at all, the departments have made a dispute resolution process available. It's called the Patient Provider Dispute Resolution Process, or PPDR. And it's very easy for a patient to file a complaint. They just go online. I think it's a $25 fee to set up an arbitration. And then a provider is then pulled into the equivalent of kind of a small claims type situation between a self-pay patient and the provider, where you have a third party decide whether the self-pay patient is going to pay you for that service at all and how much. So that, plus the risk of regulatory inquiries, investigations, and then potentially fines, is the real reason why we wanted to put this together and get this quick, hey, pay attention, see if this applies, because it isn't a huge, compliance lift, and could really save some funds.
And I think we sort of already have a process
Mm-hmm.
for notifying people, like take your example, Andrew, when someone has residential services, we already have a process where we're talking about this is how much it's going to cost per day, blah, blah, blah. It doesn't tick every single box. So it's sort of augmenting what you have in not all that significant ways, and, posting this notice.
Absolutely.
On the website, probably in your inpatient unit, maybe having something in your handbook. And so, Andrew, you look at a lot of admission-related materials, as we do, dealing with technical denials and just helping people with their forms.
Yep.
I mean, in your experience, given what people have, does it seem like this is a heavy lift to you?
No, and I think I think the patient handbook is a great idea of, it's kind of already a repository of, notices that we provide to patients, signatures we want to obtain from patients. Now here we don't need a signature, but yeah, I mean, we already see like a lot of financial responsibility information oftentimes in patient admission handbook. So I think including, your kind of form for this good faith estimate, including that in the handbook, I think is a great idea. And also, right, we talked about putting it in the IPU. I think that makes sense. Hospice obviously is more of a home-based type of care, so we don't really have in the clinics or offices where we're treating patients, so we can't go and put it in every patient's home. So I think we include it in the handbook. And then, yeah, in the IPU, where we actually have patients who aren't at home.
And then we put this notice on the website.
Yep.
But then if someone fits in one of these buckets where they are going to be charged, then we have to give the good faith estimate. The first thing we're talking about is just the notice of their general rights. In the event you are self-pay, here are your rights.
Correct.
Right?
Correct.
And the model that we're posting, is that a model of that notice as well as the good faith estimate, like template?
Yes, the departments have put out 2 documents. One is a model notice, and then one is a model form template. And you can adjust these to fit, or you can download them and use them as is. And the departments are fine with that, and they will view use of their own model documents as evidence of good faith compliance, especially during this period where they're rolling in the law and, we've got selective enforcement in some areas. So it's a good bridge to get to compliance quickly when, you've got other things to think about.
Yeah. Well, I think this has been super helpful in getting this on folks' radar screens and then linking up to tools that they can get into compliance, because the notice thing is the thing that, we need to have available to everyone. And I think there's some easy ways to integrate that. And then I would assume most often this is going to be our finance team. So CFOs should be up to speed on this, and then, adapting if they want that good faith estimate form to tailor it to what they think makes sense. But again, why we have this law isn't because of hospices. It's like, I went to the hospital and now I suddenly getting charged with, a giant fee or whatever.
Anesthesia bill that you didn't realize the anesthesiologist was out of network. Yeah, that's what it's directed at. As just as an aside, looking down the road, the departments are looking into expanding this GFE requirement out to insured patients. So this is a kind of a foot in the door or a drop in the pond, or, pick your cliche, but this is intended to grow.
Well, and I think that as hospices look to get upstream into, right now we're in this fee-for-service Medicare land, but as we want to grow our business, and if we're going to do home health or palliative care or supportive care management, whatever we may call it, this may interact with our lives more and more.
Absolutely. The more, I would think the more kind of care collaboration, care management, those sorts of services that providers begin to wrap around their core products, those aren't necessarily going to line up with what Medicare or Medicaid or health insurance offers. And so the GFE requirement may continue, and probably will continue, to bump up against, your normal processes for, how patients understand their payment and their financial responsibility.
We're getting out of our bucket of Medicare fee-for-service pays for everything. And it's going to be a continuation of having more robust payment and financial infrastructure and billing patients and working with, varied insurers and all this other stuff. I mean, our world is changing. And so I think this is, as you said, just a taste of some of the things that we're going to be having to tune to. And obviously our goal in these podcasts is to think ahead and help people think about how they might need to grow or change their business practices in light of what's coming down the pipeline and stuff. So I know this isn't probably causing sleepless nights for people in hospice right now, but right, we got to get these things on our radar screen and get integrated and just be thinking more like a payer whose revenue doesn't come 95% from Medicare, right? So
Right.
just think this is just a great example of, what the world.
The types of things you'll encounter.
Yeah.
Right.
When we get out of our silo here. So anyway, well, I think complicated, but hopefully for our listeners, we distilled this down to when the good faith estimate actually comes into play, and then ideas on how to integrate the notice requirement into existing materials you have. And then obviously the template forms that the government's produced that we're going to link to on the website. And obviously anyone can call us for questions and we can talk through it too.
That sounds great.
Okay. Thank God for Noreen, because you understand this stuff. And this is what's so great about working at Husch is just having so many different resources, because, you can't have your finger on one person can't have their finger on the pulse on every single thing. And this is one of those things.
It's a complicated industry. And this is a very niche sort of requirement that, at least in my experience, and I've been working with the No Surprises Act all year. And this is certainly a portion of it that providers are surprised about. So surprise, the No Surprises Act might apply to you.
Lawyer humor, right? We take the small things. So anyway, we're so funny. Surprise. Surprises Act, yeah. So, well, anyway, this was really helpful, and I hope our listeners find it helpful too. And I really appreciate your expertise, Noreen and Andrew, for you providing the hospice overlay here.
Thank you for having us.
Yeah, thanks so much.
Well, that's it for today's episode of Hospice Insights, The Law and Beyond. Thank you for joining the conversation. To subscribe to our podcast, visit our website at hushblackwell.com or sign up wherever you get your podcasts. Until next time, may the wind be at your back.